Yeah, there we are. There we are. I knew it was coming through. Sorry, y'all. We had a power outage yesterday, and when we have power outages, sometimes when everything comes back, the computer decides that it's going to redo all of the OBS settings without telling me. And you know when I find this out? I find this out when everybody starts going, "Hey, you're on mute." All right. So, ignore the little I can't keep my tea in the cup stain there. Aside from that, y'all like the t-shirt my son got me for Christmas last year, which I think fits the mood of the day. Uh, think that one fits the mood of the day. Anyway, my name's Mike. I'm a lawyer, not your lawyer. I am well, unless I am your lawyer. I might be your lawyer. It's possible that I'm your lawyer. But even if I am your lawyer, we've had this conversation before. Not legal advice coming out of this mouth on this stream. Anything that I say does not apply to you. That means you. It does not apply to your specific case or anything like that. Also, my bad takes are my bad takes. They're not your bad takes. Or anybody else's bad takes. But they're especially not my employer's bad takes. Or, well, anybody else you think I might be associated with. All right, moving on from the necessary disclaimers. Yes, first, Alice of Alice's Restaurant fame passed away, fittingly enough, at the start, right before the Thanksgiving holiday weekend. We do stan Alice, and we do stan Alice's Restaurant on this stream, so, but with the appropriate irreverence, so let's take the technical difficulties as our moment of silence. Aside from that, do folks have questions? I mean, questions that I might have answers to. Meaning of the universe, probably not. Things there. I will say, the hat is merchandise that is available from the Free Law Foundation. The Free Law Foundation is something you may not have heard of, but if you've been reading the court documents in this case that are available on Court Listener, you've been benefiting from their hard work. They take donations. They also sell merch. And if you do an ongoing subscription or stuff, there's little benefits like you can do more alerts and stuff like that. And if you do that, they send you a sticker pack. I picked up a t-shirt, a hat, travel mug. We also stand the Free Law Foundation here. They're good people doing good work. All right, before I get into the hearing today, can we do a short TLDR? Let me explain. No, there is too much. Let me sum up. Matt Mullenweg, the quote-unquote founder of WordPress, founder of Automatic, Automatic, because he's got that kind, well, actually to be fair, because the thing about Automatic with two T's is that it was clever briefly. It was possibly clever as recently as 12 years ago. Maybe 10 years ago. Now it's just sad. Now it's just sad. Navigator BR. Here's who you should contact. Just don't tell them I sent you. Try and contact the Law Library at the Institute for Advanced Legal Studies, IALS. That is possibly the world's preeminent law library. It is located on Russell Square in London. I've spent many hours working on their lower ground floor at the Intellectual Property Archive. decent chance that they would have the potential, at least. Um, the decent chance that they would be able to help you. I don't know what their policies are, but I've never yet met a librarian yet who wouldn't want to try to help out on something like that. Question on the range of potential damages repercussions, which I was going to get to later in the stream, but we can do now. Um, the TLDR is that it's very broad. First of all, let's set aside settlement because you can do almost anything in a settlement. Settlements are contracts. Contracts have incredible amounts of freedom in them. Beyond that, I think criminal liability is unlike criminal liability and IRS liability are near zero chances, indistinguishable from zero chances, really, as direct consequences of what's going on here. Indirect consequences, meaning the people who make the decisions on that pay attention and learn what's going on and all that. Different question. Low probability there, but less non-zero, if you know what I mean, than the probability that this judge orders something like that as a result of this case. Those odds are, just call it zero, close enough. In terms of damages, bottom end on damages, I think, is the bottom end on damages for, trial would be whatever WP proves, if they win, obviously, their actual damages are, not counting their lawyers' fees as damages. In the U.S., the general rule is that you don't get attorney's fees unless there's a statute that specifically provides for it. Next most likely thing is that they get their actual damages plus the attorney's fees, because at least a couple of the laws they're suing under do provide for attorney's fees. The reason I'm splitting it out like that is because not all of their causes of action provide for attorney's fees, and if they win on some, but not the one with the fees awards, that would drag it down. Beyond that, I would have to check, but I've got a suspicion, a sneaking suspicion, that the California unlawful competition law in question probably, I haven't looked it specifically up yet, but most state unlawful competition laws that I am familiar with provide for triple damages in at least some situations. That's not punitives, it's treble the number of the actual. It's sort of punitive, but it's not what... It's punitive-ish. Beyond that, the other big thing from WPE's view would be making the injunction permanent. Whatever injunction happens to issue as a result of this hearing, and we'll get to that shortly. Does that cover the question? As I sip decent decaf Sakura cherry tea, cherry flavored tea from Lupicia. All right. I don't want my... Okay. Yeah, whether the IRS pays attention, who knows? Is it illegal to restream a hearing? Shouldn't Matt have been able to watch normally? Matt should have tuned in sooner. But almost every court I'm familiar with restricts recording and rebroadcasting. It would maybe get him a mild "don't do it again" kind of scolding. This is your freebie if you were in the 100 who was watching it. In terms of the structural changes forced, that could be part of an injunction. but the permanent injunction could go beyond the preliminary, but I wouldn't want to speculate on likelihood there. 3 hearings in a half hour before the WordPress case isn't bad. That's moving quick. Green Girl, what'd you think of the hearings? Assuming you're not a lawyer. I love hearings. Sorry. I mean, it's a good thing. I tuned in about 5 minutes before the nominal start time, so I saw it. Yeah, the third that last one. By the way, for those of you who were part of the stream, if you tuned in at the start time, one of the prior hearings was running long. That was in part because one of the 2 litigants who was present. Okay, cool. In that case, yep, never. I just get so enthusiastic when people who aren't lawyers and aren't licensed and aren't legal professionals sit in on hearings. You know what I mean? It was so fun when I did it before I started law school, and I think I like getting people's reactions for the same reason that reaction streams are one of my guilty pleasures. That third hearing, yeah, the pro se was having trouble, and she was showing a considerable amount of patience dealing with him. Also, that other lawyer might be my doppelganger. I don't know. I mean, especially, when I trim down a little bit more. Do I have Mackenzie friends in the U.S.? Don't know. First 2 were status conferences? Okay. And yeah, her federal judges have extreme patience, but not unlimited. Good federal judges, anyway. Alright, so he's filed other lawsuits and himself been sued. Wouldn't shock me. Many pro se litigants are what are sometimes referred to in the trade as frequent flyers. Interestingly, I have reason to believe that there is actually some overlap between the frequent flyers in the pro se litigant context and the frequent flyers that I first became familiar with when I was working EMS. All right, so I think those are the initial questions. What I'm going to do is hop over. Samuel Seidler or Sidler, sorry, Samuel, has an unofficial transcript of the hearing, which I'm guessing I'm not going to inquire as to how it was generated. But this will, and I'll take that up a little bit in size. Yep, there's a link to it in the popcorn, and this will give us something to anchor on as we go through. I took a quick skim. Didn't see anything glaringly off that jumped out at me. I mean, nothing of like, wait, this isn't what happened at all kind of note. Federal judges are badasses by definition. She seems quite good. Quite bad. You know what? Far be it from me, a humble litigator, to opine on the quality of a United States district judge. Let me express myself this way. I sure wouldn't cry if I saw her come up on the wheel if I had a case in her court. Does she have one of the OpenAI cases now? One of the putative class actions that are being poorly litigated on one side? Whoops. Maybe I shouldn't have said that. Anyway, yeah. A lack of tolerance for BS is also, it's a skill that gets acquired quickly. Tremblay v. OpenAI, yep. She was also perfectly on time for the WordPress hearing. That is because a federal judge is never late, nor is he early, or she early, Frodo Baggins. All right, so let's jump into the thing. Gunners, the game that we are playing today is watching somebody else's recap, well, watching somebody else playing FAFO. So this is really an observation stream today. All right, so yep, 9,000 words ish sounds about right. All right, so calling of the cases. Appe- Kabassian seemed a little bit more anxious than Shaw did, in terms of overall impressions of the folks who spoke. I'll get to Mac when he spoke. Mac was fun. But Kabassian and Shaw, clearly they're both skilled. Clearly they're both skilled litigators. Um, Probably this is more a matter of their personal bearing. Kabassian sounded slightly more anxious to me, but only very, very slightly, and I suspect that's just because Anna Shaw expresses hers a little bit more differently. Less in the voice, more in the face, more in the posture. Shaw's expressions, I think, were a reflection of mood. I wouldn't say smug. Um, in terms of Neil Cachell not appearing, I wouldn't have been I wouldn't have been surprised if he showed. I was glad on his client's behalf that he had the good sense not to. It's fine for him not to be there. It's a large team, and Shaw is clearly a more than able litigator. Um, and Cachell is not a trial lawyer. I'm bumping the volume up a little bit, just gonna leave it there. Um, he's not at all a trial lawyer. Shaw doesn't have as good a poker face as Kabassian does. The judge doesn't have the world's best poker face, but knows it, unfortunately. I think that is her tell when she knows she doesn't have a poker face. Um, yeah, so in terms of who's being added and when, different lawyers, different skill sets, different reasons to put different people out front. I keep pronouncing Kasabian as Kabassian. Yeah, and my apologies. I seem to have that locked in my head. I'll try to break my habit, but all right. So anyway, moving forward there. But yeah, so who the lead attorney is at any particular hearing doesn't necessarily reflect status in the case or anything else. I mean, I will probably argue at hearings well before I'm lead on any case. Um, I wouldn't say people don't do things for that reason, Holt. Um, but, there's a lot of different reasons you can do things like that. Frankly, I see no reason to critique the call on any front. Good lawyer, did not have the best case at hand, did the best she could with it. Now, one of the things for the non-lawyers is that coming in at a hearing like this, coming in at a hearing like this is a very interesting game. The judge knows what the judge wants. What the judge wants, frankly, is sometimes, on some occasions, the judge just wants the hearing to be over. The judge is just going over it for the motions. That happens less now than it used to, because especially with COVID, everybody got used to more stuff getting resolved on the papers. You know, that's a thing. But the thing is, most of the time, as the attorney present, the judge knows what the judge wants. You don't. You therefore need to be prepared to adjust what you're going to do as the judge signals what the judge wants. Detecting those signals is an art form. Some litigators are better at that art than other litigators. And in this case, we came in, and I think what the judge was setting out to do basically was make a little bit of a record. Yeah, sometimes the signal is very clear. What the judge was looking to do was make a little bit of a record on the case, on the merits, and on the harm prong. But I think the judge's interests were mostly with remedies coming in. I think the judge knew that she wanted to grant some form of relief. Now, I'll get into this a little bit more. I think she may have been inclined to have given the defense what the defense wanted, which was basically a preliminary injunction that would have preserved what the status quo is now without API access, rather than rolling it back further. But I think the judge came in reasonably convinced that some relief was necessary. Was looking to make a little bit of a record in the on the transcript at the start, but was ready to move into remedies fairly quickly. So this was the point right there where I was feeling like, okay, WPE has... So let me go back also, because, okay, there we go. Winter test. What the judge is doing here, the winter test is the leading U.S. Supreme Court case on what you have to do in federal court to show you've got a right to preliminary injunction. What you have to do on that test, I think I mentioned this last time, is you need to show a likelihood of success on the merits, that you'll suffer irreparable harm unless you get the injunction, that the balance of the equities, fairness on the whole, favors giving you the injunction, and the public interest favors giving you the injunction. The last couple of elements are fuzzy, and I think they get stampeded a lot. Stampeded being when the judge just makes the outcome on a later one follow the earlier elements. Now, first of all, for the non-lawyers who are here, elements are requirements. So in order to get the preliminary injunction, you gotta meet all four elements. If you don't go 4 for 4, no injunction for you. There are other legal tests that involve what are called factors. A factor is like an element, except they're optional. Factors tests are much fuzzier, and what the judge does is sees which factors favor which side, and then kind of juggles them around a little bit and does the way, and weighs them. And I wouldn't say fingers go on scales in the way, but the judges have a lot more discretion with a factors test than an elements test. That said, I can't remember. Lawyers, if you're here, correct me if you can think of one. I can't remember an injunctive relief case where the court was like, you've got a likelihood of success on the merits and are definitely going to suffer irreparable harm, but no injunction for you because the balance of the equities doesn't favor you. I can't remember any case. The last two elements tend to fall in line when the first two favor an injunction. And when the first two don't favor an injunction, they can go any which way. So when the judge came out and said, basically, we're going to start with factor one, but I just want you to give me your best argument on your strongest claim, I was fairly confident that the judge had decided that there was a likelihood of success on something. Is there one where the first two are met, but it's denied because of public interest? That's more likely than it being denied on balance of the equities, but I can't remember one offhand. If there is, I'll bet the government is the party they're trying to enjoin. So, if the judge is saying, I don't really need to hear all of your arguments about everything, I just want your one best on your strongest, I took that as a good sign for WPE. I don't think that's the kind of question that's going to get asked if the judge thinks all of it is weak. Now, the judge, and going to the question that just came in, going to the question that just came in on this one, do I think Kasabian, I didn't do Kabassian that time, Kasabian chose the strongest claim, and like Green Girl, I understand why she chose extortion. She chose extortion because the facts on extortion are bad for the other side. And this is a case where the facts are stronger for WPE than the law, at least the appearances. The facts are definitely stronger than the law is. I'm not saying the law is weak on their side, but you really want, if you're the lawyer and you've got access to those facts and you've got access to, those statements coming from one of the defendants, you really want to anytime you can bring up the facts in front of the court, that's what you want to do. Extortion gave them the best opportunity to do that. Now, she's also right, of course, that the facts for extortion are similar for the CFAA and the common law, and the same facts go for the other things. But yeah, I would have personally said that their strongest is the tortuous interference. And I think Anna Shaw agreed with me on that one. Matt, if that's really you, thank you for the sub. I think Anna Shaw also agreed with me on likelihood of success on the merits, the strongest claim there being tortuous interference on that one. Probable. And the reason I'm saying that I'll get to, but it goes to preparation. So what we got here is, I'm going to stop you. I've got the facts. Take for granted I've got the facts. That's actually, this judge certainly seemed to be very, very well prepared. And judges do take different views, so you kind of have to start going about facts until the judge tells you otherwise. Some judges come in and say, I've read the brief, I've read the principal brief, the opposition, and the reply. I've looked at this, and this. Assume I am broadly familiar with everything contained inside, and please don't repeat yourselves. Other judges come in, frankly, having done relatively little prep ahead of time, and prefer to have the advocates make the case standing up on their feet. If you haven't appeared before a particular judge very often, no way to know. Push, thanks. As I said, if. So the judge telegraphing familiarity with the facts is good. In terms of Liamsey, sorry, Kelly Salvo's comment is directly on point there. A lot of things that are criminal, not everything that is criminal, but a lot of things that are criminal also have what we call a private right of action. Um, Meaning you can also get civil recovery. In this case, there is some dispute, and we saw that in the prior streams when I was talking about elements as to whether or not attempted extortion is actually cognizable as a civil tort. Um, it would be kind of remarkable if it's not, I think, but you never know. So, what do we have on this one? We've got the four claims relying on the facts, the judge stopping you. I've looked at the stuff, I've looked at your demonstrative, and then the judge goes on a tangent and takes a broad strip out of Ms. Shaw. Here's my take on what's happened and what has been happening. A demonstrative is sort of like an exhibit, but it's not technically an exhibit. And yeah, I believe extortion is only completed if the victim acquiesces. This is, I think, partly because new judge, and she is a new judge. She's only been on the bench barely a year, maybe a little bit more than a year, I think. I may be off, but I'm not going to be off by very much on that. So she's still settling into her role as a judge. Even big firms that often, April 2023, thanks, so 18 months or so, even big firms that, have the ability to have like an internal database that tracks people's experience with judges, so people can pull things up, or you can go down the hall and talk to another partner who's appeared, doesn't have a lot of data yet. And the judge is also going ahead and making her views on how things work in her court known. Her views on how things work in her court are, as we say in the trade, dispositive. So my guess as to what happened, a demonstrative is like an exhibit, but it's not technically an exhibit. Exhibits are actual evidence. What a demonstrative is show and tell. It's a PowerPoint slide. A demonstrative is not going to be submitted as evidence, but it's a visual aid or audio-visual aid sometimes to the presentation of your case. Frequently, I don't know about this court, but in many courts, demonstratives get sent to the court before a hearing, and they get emailed. They don't, or delivered. They don't get docketed. And the reason they don't get docketed is they're not evidence. They're not things that are formally going to be looked back at. It's something that the lawyer would like to be able to point at while arguing and would like the judge to look at during the argument. So, and yeah, sometimes a demonstrative is a diagram that's on the back of a napkin and handed up. So what I think happened is probably the procedure for submitting demonstratives is email them to the courtroom deputy. You do that at all times, at each and every single no, there aren't excuses to not do this, with opposing counsel CC'd on the email, because any email to the court needs to have opposing counsel CC'd, or it's an ex parte communication, and we had our fill of that with the Young Thug trial, right? My guess is yesterday at some point, possibly the day before, but most likely yesterday, the Quinn Emanuel folks emailed over their demonstrative, and the Hogan Lovells team decided to object, and object, reading between the lines, possibly a little vigorously. But the email address that they sent it to was the courtroom deputy's email address, not the judge's email address. So the judge wanted to make it clear that no. If you've got objections, you don't direct objections to the courtroom deputy. So I think that's what happened there. All right, so Judge, talk to me about the law. Talk to me about the law, because I've got the facts. I even went through the demonstrative with the understanding that, of course, it's going to be there. It's their demonstrative. That's the nature of the proceedings. They are, in fact, adversarial. Generally speaking, objecting to a demonstrative, particularly if the objections you're advancing are just objections to having it admitted as evidence, is there is space available to question how productive a course of action that's going to be. All right, so I'd be happy to discuss the legal issues involved in the attempted extortion claim. Good, because it doesn't matter if you're happy, you're gonna. I should add that that's because extortion's a predicate act for UCL, which knocks all of them down together, and they all warrant injunctive relief. Another reason to use extortion, frankly. But as any event, as you saw in the papers, there's some debate about the precise elements for attempted extortion. Short answer is, it doesn't matter. We're going to win no matter how you define the elements. Good argument. Anytime you can make that argument, that's an argument you make. And you really try to find ways to make that argument. If you consider the penal code, obtaining property or other consideration from another with consent induced by a wrongful use of force or fear. Hobbs Act, federally, similar definition. And then Levitt versus Yelp, 9th Circuit, 2014. Litigant must demonstrate either a pre-existing right to be free from the threatened harm or that defendant had no right to seek payment for the service offered. And it doesn't matter which one we choose to apply. So the penal code standard is satisfied as far as Levitt versus Yelp, and that's really the one they're all going to lean on. I'll first point out that at the district level, court level in that case, there's a footnote in that case, I believe footnote 5, that mentions, and I don't think she was looking at notes at this point, by the way. Very, very well prepared for her own arguments, which is good. Really, really good Supreme Court advocates, when they go to the lectern, don't bring anything with them. The way that kind of an argument is going to run, you're not going to have time to look. You need to have it there, or you might as well not have it at all. Trial court, you get a little bit more leeway, but even there, I would say that the rough rule of thumb is that if you can't put your hand on it within 15 seconds, 20, probably you're blowing your opportunity. So, regarding the first factor, there's no question the WP engine has a right to be free from a threat of nuclear war. That's kind of a tell. When somebody says there is no question, there's usually a question. They have a right to be free from being banned from the very community in which they operate their business. There's just no question about that. Repeating no question on that's a little bit of a tell, right? Then there's an or. We can satisfy the first prong or the second and the or. Stay on that first one for a moment because I do have a note to myself to ask you, what right? Like I said, no question. No. There's going to be a question. Almost every time. 60% of the time it happens every time. So you're on, and good clarification, do you mean the license to use .org or do you mean the trademark license? And the judge, zooming in, says, I bet the what right do you have to use .org without a license is a much harder question. Let's do that one. And again, the judge continually steering toward the harder questions, to me, was an indication of lean in that direction. Reason being, you can take an immediate appeal. In fact, it's entirely possible that this case goes on an effective 1 to 2 year hold by Christmas. Let that sink in. Man, I shouldn't have quoted that guy. Couldn't help myself if I tried. Because there is a right to appeal the grant or denial of a preliminary injunction. And it is, I don't believe that the court necessarily must stay, but it's pretty common for there to be a stay of proceedings at that point. And the Ninth Circuit, you go to the Ninth Circuit, pack a lunch and a dinner, change of clothes, bring a sleeping bag, and a barber. It's going to be a bit. The Ninth Circuit is extremely overloaded, and takes a while. So steering Kasabian for the harder question, and very well prepared to answer it. No connection there whatsoever. The test is not, do they have the right to be free from a trademark license? Whoops, wrong license. That's not the fact that's relevant to that prong. And then correcting herself, I will say that before September 20th, the entire WordPress community was using WordPress.org. The operator of that site chose to hold it out as part of the community hub, doesn't charge anyone anything to use it. That's how it's been for 15 years. That's the status quo we're talking about. What's with the war wording? That's the wording that Matt was using. She keeps going back to war language because that's a good fact for her that Matt was using that. The stay leaves the injunction in place until the resolution of the motion for injunctive relief. So there is also reason to not appeal if you are automatic. And at least in theory, and I'll get to this at the end, working collaboratively should drop temperature on that, but who the hell knows? And suddenly out of the blue on the morning of September 20th, defendants purport to raise something so urgent they must demand a 5-hour response from, in the form of threats to essentially declare war, scorched earth nuclear war on them. That scorched earth nuclear war is the Mullenweg quote, which we have heard many, many times because there's not a lawyer representing WPE who capable. There's any lawyer representing WPE would be using that quote every opportunity. Judge, can I ask you, I did note that your proposed order rolls things back to September 20th, and it sounds like that's what you're arguing is status quo. I thought the access to WordPress wasn't compromised until the 24th. And that was really the point where I figured that there was going to be some form of injunction. Reason being, not that much reason to dig into the proposed order if you're inclined to deny it. So, detailing out the stuff, judge getting ready to give Shaw a chance to respond, but there's still the second element to hit. Second element to hit is the defendant had no right to demand payment for the service being offered. That one's a little bit harder. That one's going to lean on their that's going to lean on the promissory estoppel claim, but I think it's a decent argument, really. Even if you do have to assess likelihood of success on the merits of the promissory estoppel. And that's because, frankly, it's a very strong promissory estoppel claim. It's a very solid promissory estoppel claim. Very solid indeed. And here, charitably put, the service being offered by defendants in their extortive demand was a purported trademark license dropped on their desk at 10:23 a.m. We know that defendants had no right to offer that quote-unquote service because it's a pretext. It is a sham. Yes. And yes, Matt. Scorched Earth nuclear war. I don't know if Scorched Earth nuclear war is going to be your actual legal legacy. Actual legal legacy on this one may be establishing a casebook case for promissory estoppel that, if you want to look at it on the bright side, decent chance that it'll be a decent chance that it's going to be a, I should put this, compellingly written enough case on promissory estoppel that every first-year law student in the United States will become familiar with it for a period of 10 to 20 years. There's worse legacies, right? I think somebody in my law school had a t-shirt made that said, "Live your life as if you're trying to avoid being in a casebook." And yes, hey, who am I to decide? I'm not the judge. Who am I to decide whether this is a joke account or not? Matt Mullenweg was kind enough to subscribe. I'm just going to keep calling him Matt Mullenweg. Why not, right? All right, so looking at the record, 15 years, no license. Until the morning. Which, yeah. Bad fact there for the other side. We also know that from the price set, right? This one-page license listed a price of 8% of gross, which is $32 million, and set that price for a 7-year automatically renewing period. And when asked, how did you set that price? It's what I thought they could pay. We did an analysis to figure out what the free cash flow was. That's how we set the number. That's not how you calculate a royalty. That's how you set a ransom. Good line, which she delivered very well. Very well. We also have other evidence in the record, including all the other WordPress hosts who use the same terminology. Then talking about the speech on November 9th, and the judge very nicely. It's also not in front of me because it's after the briefing in this matter closed, so keep it moving. Yeah, so here's another thing for the non-lawyers. Doesn't matter what happened between the reply brief and the hearing. I mean, sometimes you can get it in. But technically, what the judge has in front of her is Tinker Evers' chance. And Hogan Lovells tried to do something with the ball after that, and the judge is like, no. It is, but in the record we have long-standing use with no effort to enforce or even a complaint, and then we have the extortionate rate. Turning it over to Shaw. Shaw going immediately away from the facts and to the law, showing no private right, arguing no private cause of action for attempted extortion, and asking, basically plead it better, but we still think it fails under Levitt. Basically what's going on here, again for the non-lawyers, there are different tests that can be used. Both sides have kind of figured that they're in federal court. Levitt is the most recent Ninth Circuit case in this area. The test that applies is probably Levitt. Let me know when you find a good joke, Matt. And then going back to, again, this is, and if they go to the Ninth Circuit, they may prevail on this point. This is the thing about sometimes the legal arguments you make are the best arguments to win the case, but that doesn't necessarily make them the best arguments for your client's interests, and particularly for your client's long-term interests. What I'm seeing here, and I know I'm slowing myself down a little bit because I'm thinking this through as I'm talking, but what I'm seeing here is, I think, a little bit of that. You have no right, nobody has a right to use WordPress.org to do anything without Matt Mullenweg's consent is a strong legal argument. It is a legal argument that could have won on that element at this level, and may win on that element at the at the Ninth Circuit. But winning on that argument is, I don't know how WordPress survives without a massive fork at that point. Pyrrhic just beginning to cover it, yeah. Because once you've got a Ninth Circuit ruling that, come on, we got a lot of WordPress folks in here. Can you continue to operate the way that you are operating if the Ninth Circuit Court of Appeals says that Matt has the unrestricted right to ban anyone at any time for any reason? Corrosion Hour, I'm going to set that aside for the moment. That's a different question. But seriously, for the WordPress folks, if the Ninth Circuit says that Matt can lock anybody out of WordPress.org at any time for any reason, can you keep operating the way you're operating, or do you have to find some alternative solution? Because maybe I'm wrong. I'm not a, I'm the dude who spent not a chance in hell they will say that. Raw, what's your first time chat, so go ahead and give me your reasoning on that, please. Because I'm persuadable, and I think they would try to avoid, potentially, but it's the Ninth Circuit. And that's, this right here is, it is that argument. So I mean, it's the argument that Automatic's lawyers are making. I think there's a non-zero chance that the Ninth Circuit agrees, or the Ninth Circuit says that at preliminary injunction you can't show enough of a likelihood of success on the promissory estoppel claim, or sends it back on that. So yeah, it would survive as a private garden app store, but um, drop to something smaller and more profitable. But what I'm asking is, who besides Automatic stays? And yeah, plugin developers are pulling plugins out. Multiple people have announced they're waiting on forks. I and others are exploring alternative platforms. A friend of mine is encouraging me to use an alternative platform. GitHub and whatever the hell the blogging platform is on that. I'm a little skeptical, but I'm persuadable. Um, don't think the WordPress community can afford to wait to find out what the Ninth says. The thing about preliminary injunctions is that they preserve the status quo, so I don't know on that one. Um, and yes, Eileen Lay, but the friend who's going to advise me on this one goes out with my one of my paralegals, and she has volunteered him for the task. And far, far, far be it from me to interfere with any task assigned by Kat. I don't mess with it when she assigns tasks to me. I'm sure not gonna. And also, I do trust Eric, and I've known him for a while. Um, Plugins are all, yeah. So yeah, I mean, Automatic can, in a license sense, pull everything and publish themselves, because again, yes, um, that's a yeah, that's a thing. I mean, common open source survives on goodwill. Once the goodwill is gone, it's an issue. But yeah, for those serious about a fork in an alternative ecosystem, big businesses are going to be getting a big group of businesses together because they need stable. So it may be too late. Um, but even if it's not, if the Ninth Circuit comes down and says, yeah, technically speaking, nobody had that legal right, so it can't support extortion, what happens at that point? WordPress core committer already stepped back from contributing because of Matt's handling of this and his actions, as have others. Not sure whether the community needs a court to help make the decision. Yeah. My thinking on this is basically my gut feeling on this is better than even odds that we're past the point of no return. My question really is how close would a Ninth Circuit decision take it to certainty? Um, you know, I do think it's better than even odds right now, but I think the Ninth Circuit ruling in that regard would take it much, much higher. Um, and yeah, I was thinking about slow moving customers when I was looking at, some of the government sites that I was looking at recently here. All right, anyway, moving on. Shaw's leaning in heavily to the no right to use WP.org, WordPress.org, no right. Um, so let's first start with the trademark license. The threaded issue is the demand that was sent to them for a trademark license. There was a second option, which was to satisfy the license through providing essentially the equivalent of volunteer hours to .org based on WP Engine's own employees. And yeah. That's the issue with that, setting aside everything else on that one. The issue there is, yeah, the volunteer hours were to be supervised by Automatic. Now, neither side really dug in on that, so I'm not going to dig in on that right now. The cleanup job on their website, I don't have it at hand. Um, I don't have it at hand, but I'm pretty sure I've seen case law that says that, in fact, changing up what you do in response to a cease and desist letter is not evidence that you were doing something wrong beforehand. It's reasonable prudence in the face of risk. I do note that Shaw is using .org, and there, yeah, I mean, that's one of the things that's going to keep coming up through here is that what .org is does seem to mutate through things, which is an issue. So, additionally, if this court was to adopt that, this is the stronger argument that essentially any demand letter sent out by any trademark owner could potentially argue it was a claim of extortion if they disagree with the merits. That's a little slippery slope-ish, but hey, when the slippery slope's what you got, you make it. I mean, seriously. I don't think the slope is that slippery. The facts here are distinctive. If we turn to the second element that the plaintiffs rely on, which is the block of .org, even today, and this is, yeah, they keep pointing that you have the right to do it manually, and if you know what's going on, now possibly the judge didn't until the hearing, but if you do know what's going on there, that's not that compelling an argument, because if you can't push auto updates, who's got the time? But in any event, plaintiffs need to be able to point to some pre-existing right to satisfy this Levitt test that they're entitled to be free, and there's nothing they can point to. They seem to be arguing kind of promissory estoppel type claim. Yeah, that's all they've got, because everything was operating on goodwill until it stopped operating on goodwill. But that promissory estoppel claim is not before the court at the PI stage, right? Because you can't get irreparable harm on it. Which makes things complex, because I think if they can show promissory estoppel, that makes it easier for them to show likelihood of success of the merits on the pre-existing right, and gets very complicated in that regard. All right, judge turning them to the TI claim. Like I said, I thought that TI was the strong claim. I think Shaw thought TI was the strong claim, and I think the judge thought TI was the strong claim. And Shaw, very, very prepared. This is why I think Shaw was thinking of TI as the strongest claim. I don't know how compelling this is at the preliminary injunction stage, in part because it's fairly basic stuff. Mayor migration under an at-will. We don't know if it's an at-will because they haven't produced those contracts. Here's the thing. They know it's not. They know they're not all at-will because they were offering to pay cancellation fees. Now, that may not be in the record, but it sort of is in the record. I mean, there was reference to it, even if it's not directly there. All right. Additionally, the actual terms going back to the case, we simply do not have that there, and it is difficult to even evaluate the claim without those basic pleadings. While you have the mic, let me ask you a handful of more questions. This is, again, where I was pretty sure that things were going more in the WPE direction than contrary, because the judge didn't ask about... the judge just kind of walked away from interference with prospective relations, which is even stronger than interference with contracts, which is in part why Shaw was leaning so heavily on the contracts. The prospective relations, that would go to the at will, and it would go to other things, and it's legitimately the stronger thing. While you have the mic, let me ask more questions. Have defendants required a license agreement of any other entity? Yes, they do have sub-licenses in place for their trademarks. No mention of how many or anything else. But there are sub-licenses in place. And you may have already started to, does WordPress remain free for everyone? And now you get into, depends on what the meaning of is. If you're talking about access to the, going and downloading, it's free for everyone. What they can't do, so narrow it for me. And the judge going to, what are small business owners or others who rely on WP Engine services supposed to do if one or the other of the plugins is pulled down and disabled? Technical question that she's not doing well with, and that I will falter on a little bit. This is the kind of case where you make sure, if you're going to argue, either you know the tech or you got somebody sitting right there you can pass over to. The technical issue or technical differences is that now WP Engine has to undertake work instead of relying on free services, creating a different workflow and creating additional time and resources within the company in order to do that. Also, oceans are a little wet. And then let me ask you one thing with respect to the bond. And that was when I was like, this is going that way. I did see an argument about WP Engine being in debt to defendants. I wanted to ask, what invoices, if any, defendants sent to WP Engine prior to September 20th? There were no invoices, Your Honor. The look on Shaw's face suggested to me that, I don't know if it suggested to me is the right thing. I would not be shocked if there was some internal discussion about whether to make that particular cute attempt. And if there was discussion on that, based on both the look on Shaw's face and how quickly and forthrightly and honestly, look, that was a bad question. Shaw handled it admirably. Okay? When you're the lawyer, sometimes it's your job to get your ass kicked. Sometimes that's what happens in the morning. You get up and you're like, my job today is to go get yelled at by the judge. You sign up for it. Shaw didn't hem, she didn't haw, she didn't try to justify sending invoices after September 20th. She answered the question she was asked. She answered it honestly, simply, and without excuse. And that is the way you do that. That said, I found it pretty damn funny myself. Because honestly, that is the kind of really cute argument that an appellate practitioner might want to put in, and a trial practitioner is gonna flinch at a little bit. Because the trial court practitioner is the one who's like, the judge has a lot more ability to just dog walk me on this. I've run through my list of questions from Ms. Shaw. Plaintiffs haven't been fully heard yet. Do you want to make arguments or hand it back? The only point I would make, Shaw's like, I was present in your courtroom for your prior hearing, PI hearing, the judge, I'm sorry, chuckling. I'm going to say this. I think the judge was a little embarrassed by the kind of stammering and, not even stammering, the walk it forward, walk it back she did when she was kind of caught off guard by the pro se litigant's misunderstanding of what adversarial is in the adversarial process. I don't think the judge had any reason to feel embarrassed about anything I saw in that preliminary injunction hearing. It was dealing with pro ses is challenging. Very, very challenging. She was treating the dude with dignity. She was giving him good explanations. And she was treating him with firmness when he started to take her. When he made the mistake of taking her patience as license, she demonstrated that no. Just because I'm being patient doesn't mean you get to walk all over me. It was a very well handled hearing, and that was the hearing where I was like, I would not want to. I would not be at all sad if the wheel came up with her as the judge for a case of mine. At all. And wrapping it up and maintaining control, there are things that, skills that develop over time in judges. Everybody's got room for small change. Everybody's got room for steps forward. But dealing with pro ses, you don't want to shut them down hard. Pro se hearings, they go wrong. They go long. They're just going to go long. My doppelganger there handled it very, very well also. That is, he kept his mouth shut. Which is difficult because when you're the opposing counsel to a pro se, it can be the hardest thing in the world. It can be the hardest thing in the world. And yeah, it's the dude had the markings of a frequent flyer. Somebody whose touchstone is their cases. There are some people who they're frequent flyers because when they're at court, it's the only time they get a chance to feel like they're important enough to have somebody take notice of them. And, sometimes as the representative of society, it's not necessarily a bad thing for the judge to, handle that. All right, so anyway, 2 statements about preliminary injunctive relief that we very strongly agree in. The first is that it's drastic, and the second is that it's likelihood of success in the merits. So going back to plaintiff, run through the questions and give you a bit of airtime. But again, I've gone through everything and I want to confirm things. Can you address for me why the harm here is irreparable? And I was laughing at that point because I think I just posted on Blue Sky that I bet law librarians. Oh, I know law librarians see a lot of the pro se stuff. But anyway, it seems to me that the judge is addressing why the harm is irreparable. It seems to me that that WP Engine should do what it needs to furnish promised services and can recover the cost of workarounds it's had to implement. So I was kind of laughing at that point because I thought irreparable harm was going to take a much larger role. And addressing it as a general matter, yeah, ongoing. These have been recognized as irreparable harm in other contexts. We've got admissions in the record about the harm, and bragging about the harm, Matt. But to answer the questions on why the workaround isn't good enough, let's turn it over to Brian Mack, who does have a technical background. He does. You can look him up on Quinn Emanuel's website. Mac was in a groove. He was having fun. The judge was having fun watching him. I was having fun watching him and the judge. Everybody was having fun. Can we agree that Brian Mack brought the fun to the hearing? Um, Now, to be fair, it's easier to do that when you're second banana. Um, you know, his role here, he's basically like, you know how musicals all have that one song, like somewhere toward the middle to end of Act One, that one just absolutely bonkers, ridiculous song that everybody loves and enjoys, and then the thing goes back to kind of the regular flow. Like for 1776, it's it's Light Horse Lee. It's the Lee song. Here Lee, there Lee, everywhere Lee Lee. In Funny Thing Happened on the Way to the Forum, it's Miles Gloriosus, right? Um, and we all know what it is in Les Mis. Because it was the only well cast role in that movie. Um, and yeah, there's one song, it goes to a character who's a secondary character. Um, but yeah, and Mac had that part today. Everybody was having fun, but Mac was in the having fun thing. And yes, Master of the House. Master of the House is absolutely that song in Les Mis. Um, Defendants know. Um, yeah, so Mac starting to talk about it. I think we've heard opposing counts, and this was, I swear, this was, Mac was just like, Your Honor, everything that guy over there just said is bullshit. Um, I mean, for real. Um, Now, Brian Mack, on behalf of plaintiff, I think we heard opposing counsel refer to the block as an enhanced service for plugins and that we can't link our services. But that trivializes what was actually done here. It's bullshit. Yeah, no, just the WordPress core software, the software that defendants make available on their website, is intimately linked with WordPress.org. Um, there's 1,500 references in the code. They're hard-coded references that you cannot change. Normally, when you have an application running on your computer, you could go to the settings or the properties. You could change the update server to whatever you would like. That's not the case here, and they know it. It's completely intertwined with the data and the resources, the actual core software that you download. Every single WordPress installation relies on WordPress.org. It calls back to pull plugins and updates. And I think what I characterize this as, and I'm just gonna jump through this thing. I think what he was saying there, tech people can correct me if I'm wrong, but I think pretty much all of this breakdown before you get to the demonstratives is him saying, look, we've got a fix in place, but it's a kludge. In fact, it's not just a kludge. It's a kludged kludge. It's spit, baling wire, and duct tape. Where it's not duct tape, it's because stuff needs to, where it's not duct tape, it's because the stuff has to move and it's WD-40. So, dirty hack, yeah. I mean, it's, again, I flunked out of computer science when I realized that, after 18 hours of failing to compile an I think it was the eternal calendar. But I recognize, what they were, what they're saying that they were doing there. And yeah, it has the feel of it's quick, it's dirty, and it's gonna just be an ongoing disaster. There are probably like 8 people who are carrying, who are playing hot potato with old school beepers, right? Do you guys still use old school pagers for who's got the call? Semicolon, yes, Dinger, semicolon. Don't remind me. And yeah. Brittle is a good word for that. Most of you use services for that now, fair. All right, you're playing metaphoric. You got 4 people playing metaphorical hot potato with the pager. The main one is called Pager Duty, though. Yup. Please check out beeper.com. There we go. My wife's in medicine. They still use beepers. They still have actual pagers in the hospitals. An inoperative pager is a physical marker for who's on duty. I love it. All right, so some data is... So looking at the demonstratives, we've got 2 demonstratives. I don't want to get in the weeds, Your Honor. If you're not a technical person, if you look at demonstrative slide 12, I think this highlights it. And the judge is like, I know you're calling this technical, but I will tell you I looked at this yesterday, and let you explain it to me. Good judging. One of the things that I saw from this judge that I liked the most, because you don't always see it. Oh my God, you don't always see it, but when you see it, it's... So, had an arbitrator really impressed me with something similar. When the judge is willing to look you square in the eye and say, you know what, I don't understand a goddamn word you're saying, break it down for me, please. When the judge is like, nope, I know nothing about this. Please go ahead and tell me what's going on here. When a judge is willing to say, without apology or embarrassment, I don't know, teach me. And we saw some of this at the end of the hearing, by the way. That is, them judges as keepers. Other stuff you can fix. Not doing that? Hard to fix. All right, so Mac, and Mac was in and off mic on this because he was he was over at the bench pointing to specific boxes. He talked it through well, and he met her where she was. Mac did that very well. The mirror is a temporary and partial fix. And then, Mr. Mac, let me ask you and tell me if this is not best directed, but why isn't an injunction restoring access to the open source as suggested by defendants enough? And that was when I knew they were getting something, but I thought they were probably going to get effectively nothing or very little. And this is where Mac saved it. He said, it's basically what I explained before. The access they're talking about is manual one by one. We would lose the api.wordpress.org access, which is servers communicating with servers. The admin panel automatically calls back to the server to update the plugins. They get notifications coming back. Users wouldn't even know when there's an update available. You wouldn't know on your iPhone if it didn't tell you, and you probably have it set to update automatically all your apps. You would have no way of even knowing that an update was available, so this API is critically important. The password-protected resources, everything goes through login. Those are also critically important because if you're posting a new application, that's where you would post it. If you do it anywhere else, nobody knows it's there. So we're losing all the functionality at the bottom, and that, I think he was pointing at the demonstrative, which is this plugin submissions, which is supporting our plugins. All of these things, there's been a big community built up. So by effectively banning just plaintiff from those resources, the only way we would be made whole is getting access back. And then having the question for both sides, having reviewed everything, I'm inclined to grant some sort of injunction, but yours is a non-starter, it's too broad. My question to both sides, is there any interest in you all trying to narrow this together, or do you want to just see what I produce? Understanding that, Mr. Mack, I'm assuming on the defense side as well, you all have much better technical access. And this is the point where Mac, man, he was in the groove. He was having fun. He was doing so good, and, oh, he just got out over his skis. Oh, just center of gravity was a little bit of an issue right at that point. Because the answer at that point is, as soon as she said, "Is there any interest in you all trying to narrow this together?" This, from here over, that is the right answer. That is the only right answer. It is the single only right answer. There is no other right answer at that point. That is the answer. There is one answer. One answer to rule them all. Yes, Your Honor. And Mac started going to just last weekend, which the judge had telegraphed she didn't want to see. Every weekend there's something new. This guy just will not come up. The menacing minute was probably more text stuff, but yeah. He finished by saying, we need more than status quo ante. We need them to stop doing more. And the judge is like, well, the problem with the PI is that you just get status quo ante. And that's where Kasabian rushed up and grabbed him by the belt and dragged him back up over the skis. That was a very clear move to rescue. And it was well executed. And I'm not blaming. I'm laughing a little bit, but I would like to think and like to hope that I'm laughing more with Mac than at him. It's so easy. All right, so actually, let me back up and give you a little bit more inside baseball. What Mac was doing very, very well there is the second hardest thing to do as a litigator, but also probably the most important thing to be able to do as a litigator, and that is to engage the court in a conversation. Not a question-answer session, but an actual conversation with the court. The ability to take the thing from a classroom or an imbalanced setting to a we're all smart people working this out together. That's an incredibly hard thing to do. You don't get a lot of opportunities to start that engagement point. You have to take the ones you get. You have to be able to get to them. And Brian Mack did that damn well. You could see that the judge was engaging with him, and the judge was conversationally really engaging with him. The problem with that is that it's not actually a conversation, and sometimes you get too caught up in the conversation and you miss a warning signal or two. Happens. And again, I mean, what Mac was doing is the second hardest thing for any litigator to do. And he did it well. He just needed a little bit of rescue there at the end, but it was a well executed rescue. So, Your Honor, in addition to what Mr. Mack has just explained, I would love to say a few things. Absolutely, we would do the thing you just very strongly telegraphed we should do. Yes, we're doing. Yes, we're doing that. Oh boy, we are doing that. Yeah, we're all for that, Your Honor. Yupper. There is nothing, chat, in the world she wants to do less than work this with opposing counsel. Not a thing she wants to do less. Not a thing opposing counsel wants to do less here either. Because you got to have room to meet in the middle, and I don't think that room's there at this point in time. But if the judge says that next hearing, I want you all to show up with a bowl of dew, a bowl that you have knitted out of spider webs and used to collect the morning dew, you take up knitting. So we would be happy to revise and meet and confer. No, I mean, you're going to at that point. We want it to be enforceable and clear within its four corners, but Mr. Mack's also right. This guy won't shut up. And then talking to Shaw making her point about we've got a right to compete, which is a valid point. We also, agree that stuff is there, but we are also happy to meet and confer. But I hope the court can appreciate the importance of any resolution respecting that line between competition and unlawful activity. And the judge is like, yeah, don't worry. I'm doing homework on antitrust every night. And Shaw's like, if I could just make a second, if you could pull up that slide 12. And talking about, this was a bad move, but Shaw did well really until about this point in the hearing. I think she got thrown by the from the bench loss. I don't know that she was expecting to win, but I think the from the bench threw her for a little bit of a loop there. She still did more than competently, but I think she was off stride a little point from there down. Because she's backtracking and trying to go through, and this is, Shaw saying, I think what Mac's presentation shows is they do have a way to solve it. They just don't want to spend money, and that was a risky thing. Pointing out also that, Kasabian trying to save it by pointing out that objections never did get filed, and you're kind of supposed to do that first. And the judge is like, yeah, but the most important person in the room, second most important person in the room. The second most important person in the room has questions. First most important person in the room is anybody? Bueller. I love seeing that scene as a meme. But lawyers, tell the chat who the most important person is in at any recorded hearing or anything else. Holt's got it. Holt knows. Yep. Judge is number 2. Court reporter is number 1. Because if the court reporter don't write it down, it didn't done happen. Everything depends on the record, y'all. And the record depends on the court reporter. So the judge is like, yeah, I got objections, though. And the thing is, the judge might be number 2, but Kasabian's a distant third at this point. I understand. So just hearing this for the first time, let me think on my feet. It won't be hard. We can do this. And if we're unsuccessful, we'll submit competing proposed orders with perhaps, if Your Honor would hear us, maybe a 5-page brief. She had to ask. There's no way this isn't going to competing orders. I mean, no chance. Shaw going, I think it might be worthwhile for us to meet and confer first and then advise the court. And the judge is like, yeah, meet and confer. Meet and confer. Meet and confer, I swear, judge's favorite words are meet and confer. And if it ends up being that you can reach agreement, you'll get me that. If not, give me dueling submissions, and if I want anything after that, I'll tell you. That works, Your Honor, is the only right answer at that point. Because if it doesn't work, you make it work. It will probably, 5 pages is in the right ballpark, but because we're lawyers, I need a timeline. Yup. Remember on Blue Sky when some schmuck was like, I don't give students extensions because there are no extensions in the real world. Oh my god. I was like, oh crap, I've got no plan for my anniversary and it's in 3 days. And my brain immediately goes, can I get an extension? If you do not give litigators timelines, it does not happen. If you do give litigators timelines, it often does not happen until, 2 or 3 extensions. Extension, everything, there are a couple of statutory things that can't get extended. Everything else routinely does. Your Honor, we can work on it today and tomorrow and then go eat. That's our position. This is an emergency matter. We will move with all due haste and submit something first. So they went back and forth, and basically the resolution is that Kasabian gets to turn stuff in on the 27th and have Thanksgiving. Hogan Lovells gets to work over Thanksgiving, but they get the weekend also. That's the overall there. So the judge is like, yeah, try for Monday, get the draft going. We'll take it from there. We'll ask that no further wrongdoing. Shaw's like, we'll ask on this point. And the resolution is basically try and maintain the status quo from now until Monday. In other words, Matt? Okay. And then there was some more housekeeping stuff on amended complaint. This is the judge, by the way, going, go ahead and teach me. When the judge is like, yeah, please, give me the case. We can hand it up on a Post-it. And this was, no, was what I interpreted as, what I interpreted is loosely paraphrased as, all y'all need to put your heads down on your desks, have a banana and a nap right now. Kasabian getting the citation, and the judge is like, please, I could use, because if you're right and I'm wrong, I'd rather get this. And Kasabian doing a great job of being, it's not that you're wrong, Your Honor, it's a quirky little rule that I hadn't even stumbled over until this case. But somebody thought of it and made the argument, and the Ninth Circuit said it's not untimely. 806 F 3rd, 1002 at 1008. And if somebody wants to look it up, that's fine. I'm going to assume that she's got that down. She seemed pretty confident. And the judge is like, you have to love the rules. Thank you, counsel. And we are out. So, questions. I've been giving you my thoughts as I went along. My thoughts on what those competing proposals need to contain. Both sides clearly need to walk back. If I was WPE, I would walk back any demand for Slack or forum access. Maybe they have to give it to you anyway to give you the other stuff, but that's a them issue. Go ahead and walk that back. Beyond that, there's only so far that they can walk back, but I think what they hold out for what I think you do really is you drop most of the enjoining Matt from talking stuff. That's like enjoining the tide. You can be King Canute if you want, but it's not going to work. And if I was the judge, the last thing I would be inclined to do at this point in time, I gotta say, if I was the judge, the single last thing I would want to do right now is try and stop Matt Mullenweg from talking. You do not want to issue an injunction that you are going to have back in front of you on a contempt motion 3 times a month, on a good month. Is the request for keeping things as they are until Monday actionable if when Matt does something stupid this weekend? Probably not. I don't think it's a clear and direct order of the court that would lead to contempt if disobeyed. However, if it's disobeyed, it's gonna affect, for sure, it's gonna affect the injunction that gets issued. Um, so yeah, if I was the judge, I would not want to issue an injunction that limited Mellenweg from talking, because I don't want. Ain't nobody got time to deal with the consequences of that. Yeah, don't order something you don't want to enforce. I would not want to enforce that. That's going to largely be competitive harm to the extent that it's unfair competitive harm. Most of that harm, just keep it going. So, I mean, I think if I'm WPE, I push for that API access. I push for restoration of the admin panel, my ability to I push for the admin panel. I push for the ability to update plugins, etc. That kind of login access. And I think I put in, if it's a competing proposal, the stuff about forking ACF, but I do that mostly for to get that in front of the judge. It's not even a fork. I know it, and I know I get that, but it's the art of the possible, right? So that's what I kind of push for. If I'm Hogan Loveless, I got problems. The checkbox should probably go, but I don't know you make a huge thing. I'll get the question, Liam Z. Don't worry, I'll get there. If I'm Hogan Loveless, I got an issue, right? And the issue that I got is that you gotta give ground right now. Okay? The judge said an injunction is being issued. The judge said the injunction is going to be something different from what you're asking for. That means you need to give more. If you can't find a way to give more, you got a problem. Now, frankly, in a sane and rational world, that's what what I just tossed out there is probably where you land. Can they land there? That's going to be the question. If they can't move, it's going to be an interesting Monday. If they can't move, it's going to be a very interesting Monday. Effectively, I think we will see an injunction against Matt charging for access. In effect, if not in name. In terms of what happens on the appeal, it is theoretically possible for WordPress to file for emergency relief in front of the Ninth that would stay the injunction pending the appeal. I think that would be unlikely to succeed in these circumstances because there is no harm at all. I mean, and clearly no harm to automatic from a status quo injunction in this case. The status quo was in place for 15 years and it's in place for everybody but this plaintiff. But theoretically speaking, they could get an emergency stay of the injunction. Without a stay of the injunction pending appeal, the injunction remains in effect throughout the appeal. Which means that when everybody comes back to court in 18 months or 2 years, the temperature is probably going to be a lot lower, which is probably going to be much more conducive to productive litigation. I mean, the nice thing about a long appeals process for something like this is that it very, very much gives you time to let the temperature drop. All right, questions. Matt, other people know your first time here. The helmet is an Andrew Ainsworth made out of the original molds, and it might be my pride and joy. My pride and joy beyond the kids, and my wife and my family. And okay, so it's not high on my pride and joy lists, but I mean, it's a cool thing to point at, right? The Rebel helmet, on the other hand, that's being used as a shirt rack, is from Disney World. Kapua. People want you to say hi again. Kapua. Might be out being walked. My wife came. The buzzing noise was my wife's kitchen devices. Kapua. Josh, is mom and the dog home? Okay, my son's got his earphones in.
What?
Is Kapua around?
Kapua?
Nope.
Kapua?
All right, I think she's out being walked. Sorry, you'll catch her on the VOD. She made her appearance at the start. Wouldn't an injunction against charging for excess be overreach? Yeah, and it wouldn't be, like I said, it would in effect be that, because the thing about an injunction is, well, maybe it wouldn't in this case, but the thing about an injunction is that while it only applies to the litigants at hand, you got to be pretty foolish, particularly in a case like this one, where any other dispute is going to wind up in the same court, and almost certainly, because of related case rules, in front of the same judge. In effect, that's where we wind up, right? Because if you're Hogan Lovells, you don't want to be back here with 2 or 3 more other litigants when there's the injunction in place. So, yeah, Carrie's the one making the point that you have to really be ignoring your lawyers to do something like that. So, but in the sane world, in the reasonable world, in the rational world, and in the not totally and completely lunatic world, you're pretty careful about teeing up another case with the same issues in front of the same judge. And again, because Automatic is in Northern District of California, Automatic can always be sued in the Northern District of California, and any case that is about access to WordPress is very likely to meet the requirements for a related case, which means that instead of random assignment, it goes to this judge. Other questions? Do I expect Matt to continue to go after all their customers with the current level of aggression? I'm not expecting anything anymore. Not in this one. Drake and multi-state filings. Man, nobody has lost a rap battle in the history of rap that bad. Can you archive? Yeah, absolutely. This one's archivable. A couple of streams ago, I suggested most probable scenario was eventual settling before trial. Still think that? It's never an unsafe bet. All right. Gonna give you a deep. I'm gonna give you a very, very deep sci-fi reference here. Okay? Betting on a case to settle before trial is like betting on the leading apprentice jockey to place. And if that doesn't show you how much of a geek I was when I was in high school that locked in my head, I don't know what will. and what kind of painful, awkward, libertarianish geek I was at that. Blah, 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 blah. Say someone left automatic and fell in love with the stuff, especially the writing, argument structure, and subtle humor. Is 45 way too late for law school? I graduated when I was 40, and I wasn't the oldest person in the class. And there are hybrid part-time legal programs in addition to full-time stuff. University of Hawaii actually has a decent hybrid model, 4-year program. Did I see the post about the TikToker trying to trademark minimalist vibes as trade dress, except I think she's trying to copyright it as trade dress. And the magistrate judge appears to be going for it. We'll talk about that one time permitting. Was that Lazarus long? Warm. Warm, edging toward hot, but not quite. First time question. Do official transcripts reach Pacer? Yes, but months later. Months later. Mike, it was Mike? Yes, Pangolin, it was Mike. Pangolin coming in for the win on this one. But I always thought Pangolin was that type of geek also. McGeorge has a good reputation. In fact, one of the local judges that I'm very familiar with went to McGeorge. And yeah, before they come up on the docket, basically the court reporters make a good chunk of their income from selling transcripts. They get a large exclusivity period. Thought on having judges or DAs do mandatory public defender hours each year? Not judges. Not judges at all. Judges should not advocate. They should be out of practice of law business entirely. DAs and public defenders, a lot of British criminal lawyers, criminal barristers to be specific, do both. So, I don't know. So the mic in here was, it was in there because they funded stuff off horse racing. Irrevocable exclusive royalty-free license to archive my scrape dreams. We just go with it. It's CC Bide. Always sad when an old-timer stops betting on the ponies, indeed. How significant do I think the case is as a precedent for open source? If you're open source, you watch this very carefully every step of the way. Very carefully. Every step. The dog's back. Kapua! Kapua, you want to say hi to the, Yeah. Oh, yeah. Oh, you're so happy because you just got a walk. Yes, you are. You got dinner and a walk, and you are the happiest you are at any point in the day. Yeah. Oh, go get brush. And now you're getting brushed, which is even better. Yeah, go see mommy. Go see mommy. That's a good girl. All right. She is a creature indeed. That is our half collie, half, I don't know. She is our half collie, half, we don't know. You can tell by her size, she ain't collie. Not 100%. No, she's not a North American fence jumper, she's an English fence jumper. We got her in England. All right. Any other questions? If not, I'm going to go, we're at the 2 hour on the nose mark. So I'm going to get rolling because my wife is home. It is coming up on Thanksgiving. Quarantine is nothing anymore as long as you do your paperwork months ahead of time. You guys, update for stream time, stream scheduling. Who will win the case? I would rather be WPE than automatic, but there's space for it to go both ways. Stream dates. So here's the deal, basically. I'm an Oddfellow. Tuesdays is Oddfellows nights. Well, at least 2 of the Tuesdays a month are Oddfellow nights. At the same time, there's a lot of Thursdays that aren't going to work coming up, right? So let's take a quick look at... Well, but then again, there's a lot of Tuesdays that won't work either. Okay. Here's what we're going to do. We will stream on Tuesday the 3rd. So a week from today we will stream. Thursdays we will do Thursday again, 12th, 19th, 26th, and 2nd. Stream and the 7th. And then miss a week while I'm in Japan and then should go back to normal. Abnormal. Something in between. No, this one was the Tuesday streams are going to be at the earlier time. The Thursday streams will be at the regular. Because when it's not Oddfellows, it is, and checking, yeah, the 7th is an Oddfellows night. When it's not an Oddfellows, I game now on Tuesdays and Wednesdays. So, either or. Do I have any advice on how my friend can convince a judge to look at her 27 8x10? No. Come on, Winston Works. 27 8x10 full-color glossy photographs with a circle and arrows and a paragraph on the back of each one explaining what each one was to be used as evidence against us. No. Because it's going to be a typical case of American blind justice, and the judge wasn't going to look at the 27 8x10 color glossy photographs with the circles and arrows and paragraphs on the back of each one. And we was fined $50 and had to clean up the garbage in the snow. All right. Take it easy, everybody. Have a great Thanksgiving. Have a great weekend. Try not to, get mowed down by crowds in grocery stores on Friday. Grocery stores. Not grocery stores, what I meant. And until next Tuesday, my name is Mike. I am still a lawyer. I am still not your lawyer. But mahalo for watching, and aloha.